Welcome. I'm going to call to order the Rhode Island Ethics Commission for the fifth meeting of 2025. We have a quorum present. And the first item on the normal agenda is a motion to approve the minutes of the session held on March 4th, 2025.
So moved. Second.
Motion by Commissioner Harris, and second by Commissioner Luzzi. Commissioner Susie,
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner,
Aye.
Commissioner Sereni,
I was absent at that meeting, so I abstained.
Commissioner Harrison,
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The next item is the director's report.
Good morning.
Good morning.
So just briefly to start, noting that we're live streaming. Some people watching through the live stream. The meeting agenda is on our website, as are the meeting materials, copies of the draft advisory opinions. We will live stream the entire open session. When we get into executive session, the live stream will stop until the executive session ends. Then we'll come back into the live stream for open session. At that point, the chair will report out any actions taken in executive session, and will also post actions taken in executive session in writing on our website shortly after the meeting concludes. So with that said, getting to the director's report, with complaints and investigations, we have 3 complaints that are pending right now, since we disposed of one at the last meeting. One of those is on today for initial determination in executive session. The other 2, I really don't have anything to report on those. Forcing complaint is still discovery ongoing. And I will note in the other complaint, Heidi Weston Rogers, that is a complaint that's under investigation, and we're planning on scheduling the probable cause hearing for our very next meeting. So that'll be April 8th. I anticipate. Moving on to advisory opinions. We have 18 advisory opinions pending, and that's a big increase over how many we had last time. They're just really coming in quickly, and so we're working hard to turn them around. That's why we have 7, is it 8 on today's agenda.
Who's counting?
We, traditionally, I tried to keep it down to a more manageable number for the meetings, like around 6 seems to be the sweet spot. But when we have this many in, we're just trying to turn them around. So we're going to keep noticing them as fast as we can on the agenda, so you can anticipate lots of advisory opinions for the next couple of meetings until we catch up. Moving on to APRA requests, we did have 7 requests since the last meeting. As you know, we try to complete all of them in the same business day. And 6 of them we were able to do. One of them, it took us 2 days to complete, unfortunately. Right, and that was a pretty complicated one, where it was a broad search for everything having to do with certain advisory opinions, from the request letters to the withdrawal letters and staff correspondence. So it took a couple of days to make sure we had it all. 2 of those requests related to complaints, 3 related to advisory opinions. 1 had to do with a request for some training materials from one of our trainings last year, and 1 related to financial disclosure. We still get them related to financial disclosure, even though they're available on the website now, but some people just would prefer to get them emailed. Then with financial disclosure, we are really in the thick of the financial disclosure season right now. So all of you who haven't filed yet, including myself, should have received your blue letter in the mail. If you didn't, talk to me after the meeting. But I expect that you did last week. We mailed those all out last Monday. And as of this morning, since that mailing, we've received about 1,000 financial disclosures. And there's a lot of that processing that goes into all of these. So it's kind of an all hands on deck situation. Even right now, one of our investigators, instead of being in the meeting, is answering the phone right now because it's just nonstop telephone calls. But we've been through it before. We know that we've got a busy, maybe 3 or 4 weeks ahead of us. Disclosure. And then finally, just general office matters. I already mentioned the next meeting is April 8th. And I'll also note that after we get through advisory opinions today, we've got an agenda item for that common cause petition for rulemaking and we'll talk about that. That's all I have. Does any of you have any questions?
Do I have any questions?
Of course.
In a past meeting, there was discussion regarding the monetary limits in the gift rule. You foresee any type of report from the staff on that?
I do, and thanks for asking. So one of the issues that I'll talk about when we get to that common cause petition for rulemaking, but touch on it a bit now, is that I'm preparing a memo to help the commissioners kind of understand those issues, also looking at different states and how they handle lobbyists. And as part of that, my intent was to include in that memo, since I'm already looking at gift rules in other jurisdictions, to put in what the limits are in those other jurisdictions also, whether it's 25, 50, 100 or 0, whatever it could be. So I'm hoping to have more of a comprehensive memorandum for you on both of those issues when I get it to you. So that's still on the table.
All right, thank you.
All right, we have advisory opinions next. The first on the shot sign up sheet is Louise Dinsmore, a member of the Charahoe School Committee.
Good morning, everyone.
Good morning.
The draft for this petitioner is at tab A in your binders. Welcome, Ms. Dinsmore.
Thank you.
The petitioner is a member of the Charahoe School Committee. Under current state law, local school districts are required to provide and fund transportation for students who live in those districts but attend private schools. At a recent meeting of the school committee, the superintendent of Charahoe Schools asked the school committee to support a resolution requesting the Rhode Island General Assembly to amend the state statute to require private schools to share in the cost of transporting children from the local school district to the private schools that they attend. As the parent of a student that attends private school, the petitioner seeks guidance regarding whether she is prohibited from participating in school committee discussions and decision-making relating to whether the school committee should support the resolution. The petitioner may not participate in any matter in which she has a substantial conflict of interest, meaning that she has reason to believe or expect that she, a member of her family, a business associate, or a business by which she is employed or which she represents, will be directly financially impacted as a result of her participation. The petitioner will have reason to believe or expect that a conflict of interest exists if it is reasonably foreseeable. What that means is that the probability of the conflict of interest is more than conceivable, but less than certain to occur. In order to determine whether the provisions of the Code of Ethics cited in the draft are implicated, the Ethics Commission must first ascertain whether the petitioner will be directly financially impacted by the official action that is under consideration, which in this case is supporting the resolution that I described. If a direct financial impact, be it positive or negative, is not reasonably foreseeable as a result of the petitioner's contemplated official action, then the petitioner will not be required to recuse. A highly analogous fact pattern was presented in the draft in Advisory Opinion 2012-2, which states that a member of the Exeter Town Council, who in his private capacity was a licensed firearms dealer, was not prohibited from participating in the town council's discussion and voting on a resolution asking the General Assembly to change the state law regarding municipal licensing of concealed weapons. Most relevant to the instant facts, the Ethics Commission noted that the action taken by the town council in that particular matter in approving the resolution would only result in a request to the General Assembly to change a law that the town was not empowered to amend. Similarly, here, should the school committee ultimately vote to support the resolution, such action would only result in a request to the General Assembly to change a law that the town is not empowered to amend. Additionally, even if the General Assembly were to amend the state law, there would still be no direct financial impact upon the parents of private school students like petitioner. Rather, each private school would then have to decide whether and to what extent to pass off additional costs of student transportation to those students' parents. There is no direct financial nexus between the resolution pending before the school committee and the petitioner's personal finances. Therefore, it is the opinion of staff that the petitioner is not prohibited by the Code of Ethics from participating in school committee discussions and decision-making relating to whether to support this particular resolution. I'm happy to answer any questions or to defer to Ms. Dinsmore as appropriate.
Thank you. Ms. Dinsmore, welcome.
Thank you.
You've heard the staff report. You had a chance to read the advisory opinion before you came.
I
Do you have
did.
anything to add or to comment on?
No, I just, in an abundance of caution, I just want to make sure that I'm doing the right thing. You know, I'm a new chair of the Charahoe School District. Transportation costs are, a hot button issue around the state. And, as Ms. Radish just mentioned, I do have, a child who attends a private school. So I just wanted to make sure that I was doing the right thing and being proactive.
You're comfortable with the opinion you got?
Yes, sir.
Is there a motion to approve and issue the advisory opinion as presented by staff?
Move.
Second. Motion by Commissioner Santorini, second. Have a discussion or question for the presenter? Any discussion? There being no discussion, roll call vote. Commissioner Susan,
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner. Aye. Commissioner Santorini.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Unanimous, thank you.
You're gonna need a computer that doesn't see. Thank you. Have a nice day.
Thank you. The next item, sign on the sheet is the Honorable Paul Santucci, a member of the Rhode Island House of Representatives.
Good morning, Commissioners.
Morning.
Morning.
This draft advisory opinion is on the top F in your binders. Representative Santucci is a newly elected member of the Rhode Island House of Representatives. He represents District 53, which includes the towns of Smithfield and Gloucester. He resides in the town of Smithfield. In his private capacity, he owns a financial planning business located in the town of Lincoln. The landlord of his office space in Lincoln is planning to develop a major industrial park in Smithfield. And Representative Santucci has not been involved in the project. However, he represents that his landlord has asked him whether he would be willing to express his support of the potential development in his own legislative district. Cognizant of the Code of Ethics and wanting to comply with the requirements of it. He's seeking guidance from the Ethics Commission regarding whether he may, in his official capacity, publicly express his opinion relative to the potential industrial park development, which may include but not limited to discussing the matter with members of the press or others in the community, and potentially participating in the General Assembly's discussion and voting on any potential legislation that may have to be introduced relative to that development. Under the Code of Ethics, a public official may not participate in any matter that is expected to financially impact himself or, among others, his business associate. Additionally, a public official is prohibited from using his public office or confidential information received through his office to obtain financial gain again for himself and, among others, his business associate. Further, a public official must recuse from participation when his business associate appears to present evidence or arguments. A business associate is defined as a person joined together with another person or to achieve a common financial objective. The Ethics Commission has always opined that the relationship between a landlord and a tenant is one of business associates. Here, the petitioner and the industrial park developer are business associates given their relationship as a landlord and tenant. Thus, the petitioner is prohibited by the Code of Ethics from participating in his official capacity as a state legislator in the General Assembly's discussions and voting on any legislation in matters that will directly financially impact his landlord on the anticipated industrial park development. These actions may include, but are not limited to, drafting, introducing, discussing, or voting on legislation directly financially impacting the anticipated development or the petitioner's landlord. Prohibited actions would also include any use of the petitioner's office to publicly comment upon or support that development. Currently, there is no legislation pending before the General Assembly, thus the Ethics Commission's advice hearing is general in nature. Accordingly, if and when a specific piece of legislation is introduced, the petitioner is advised to either recuse or seek further guidance from the Commission. However, the Code of Ethics does not prohibit the petitioner in his private capacity as a resident of Smithfield, a taxpayer, to express his support of that development publicly. I'm happy to answer any questions you may have.
Representative Santucci, you've heard the report from staff, so you've had an opportunity to read the opinion before you came.
Yes, sir.
Did you have an opportunity to work with this? Get where it got discussion further about it?
Yes, sir.
Do you have anything you want to add or comment on the report?
It's just, this may never come to fruition. I have no idea, but I wanted to be doing the right thing the right way, ahead of time, and it's a.
Thank you. I'm going to open it up for questions now. I forgot to do that the first time.
Yeah.
Any questions? Is there a motion to approve and issue the advisory opinion as presented by staff? Commissioner Ritchie, motion second. Commissioner Susie. A roll call vote. Commissioner Susie.
Hi.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Harrison.
Aye.
Mr. Peterson.
Hi.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Thank you.
Thank you very much.
Thank you.
The next item on the sign-in sheet is the Honorable Arthur J. Corvese, a member of the House of Representatives. Good morning, sir.
The tab for this petitioner is D in your binders. Welcome, Representative Corvese.
Thank you.
The petitioner is a member of the Rhode Island House of Representatives and recently began his 27th year of public service in that capacity. It won't be long before the state's operating budget proposal for fiscal year 2026 comes before the House for a vote. Representative Corvese explains that the budget proposal, including all of the articles contained therein, will first be sent to the House Finance Committee for consideration. Representative Corvese is not a member of the House Finance Committee. The House Finance Committee will then draft a final version of the entire budget proposal for consideration by the full House, who for all intents and purposes will vote yea or nay as to each of the budget articles presented. Representative Corvese informs that Article 5 of the state's operating budget proposal seeks to impose a digital advertising gross revenue tax rate of 10% on companies with annual gross revenues exceeding $1 billion. Last May, the petitioner's son-in-law, Mr. Lenz, became employed as the Director of Public Policy for Meta, a company that would be subject to the digital advertising tax that is included in Article 5. Chief among Mr. Lenz's professional duties is the monitoring of legislation of interest to Meta in 19 states, including Rhode Island. Mr. Lenz is paid a salary and is eligible for bonuses, which are contingent upon a number of variables related to his position. Those bonuses are not dependent upon whether or not Rhode Island legislation is passed or defeated. Mr. Lenz does own some Meta stock, roughly 200 shares of Meta's 2.5 billion outstanding shares. The value of those shares fluctuates, but they are currently worth about $600 per. Importantly, Mr. Lenz informed Ethics Commission staff that the value of Meta stock would not be directly impacted by the passage or failure of Article 5 in the state's operating budget proposal. Petitioner's question for the Ethics Commission is whether he may participate in General Assembly discussions and voting relative to the state's operating budget proposal for FY26, including Article 5 contained therein. The provisions of the code identified on page 3 of the draft outline certain prohibitions, such as a public official must recuse from taking official action in a matter if it is reasonably foreseeable that a conflict of interest exists, meaning that he, a person within his family, his business associate, or a business by which he is employed or which he represents, will be directly financially impacted as a result of his participation. Regulation 1.3.1 addressing nepotism prohibits a public official from participating in any matter as part of his public duties if he has reason to believe or expect that any person within his family or a household member is a party to or participant in such a matter, or will derive a direct monetary gain, or suffer direct monetary loss, or somehow obtain an employment advantage. Regulation 1.3.1 further prohibits a public official from participating in discussions or voting relative to a budgetary line item that would address or affect the employment, compensation, or benefits of any person within his family. However, a public official is not prohibited from participating in discussions or decision-making relative to approving or rejecting the entire budget as a whole, provided that the person within his family is impacted by the entire budget as a member of a significant and definable class of persons and not individually to any greater extent than anyone else in the class. The Code of Ethics does not generally require a public official to recuse from participating in matters that involve or financially impact a family member's business associate or a family member's employer, unless there is also some corresponding benefit flowing to that family member. 2 examples are cited on pages 3 and 4 of the draft. The code clearly prohibits the petitioner from participating in any matters, including budgetary line items, as part of his official duties in which his son-in-law is likely to be directly financially impacted, be it positively or negatively. Here, the proposed tax contained in Article 5 would directly financially impact Meta, the company that employs the petitioner's son-in-law. Mr. Lenz has represented that the value of Meta's stock would not be financially impacted by the passage or failure of Article 5. Even if the value of Meta stock were to be financially impacted, hypothetical, Mr. Lenz's stock ownership is minuscule in comparison to the number of outstanding shares of Meta stock. It would not be reasonably foreseeable that he would be directly financially impacted. Footnote 5 on page 4 references a very recent advisory opinion addressing that particular issue. Also, the petitioner expressly represents that Mr. Lenz's compensation not based on whether or not the subject proposal passes or fails. Accordingly, it is the opinion of staff that Representative Corvese is not prohibited from participating in General Assembly discussions and voting relating to the operating budget fiscal year 2026, including Article 5 therein that recommends the aforementioned tax to which his son-in-law's employer would be subject. The draft does acknowledge Representative Corvese's preparedness to recuse from participating in matters at the General Assembly when his son-in-law or Mr. Lopes, the state lobbyist, who is supervised by Mr. Lenz, appear to testify. There is information in the draft regarding Regulation 1.2.1 on additional reasons to recuse, except for a period where public comment is occurring. To the extent that Representative Corvese ever wishes to revisit this particular issue, if and when there is a matter pending in which his son-in-law is expected to testify, we are absolutely here for him. The focus on today's presentation was his actual question about the budget and the article. I'm happy to answer any questions or to defer to Rep. Corvese as appropriate.
Representative Corvese, you had an opportunity to review the advisory opinion before we came here today,
I have, sir.
and you've had an opportunity to discuss it with Mr. Duchess.
I have.
Do you have any comments or additions to make to the facts of the report?
Not at all. I appreciate the efforts of Mr. Decius and the committee. I just wanted to get clarification since I've never had to really find myself in a position where a member of my family was actively involved in legislation. So I just thought it was appropriate for me to ask for an advisory opinion.
Any members of the commission have questions or comments for Ms. Radishis or Representative Pavese? Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Rabbit, is there a second? Second by Commissioner Brown, is there any discussion? A roll call vote. Commissioner Susie?
Aye.
Commissioner Stroud?
Aye.
Commissioner Browner? Commissioner Centerini?
Aye.
Commissioner Harrison?
Abstain.
Commissioner Peterson?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
Chair votes aye. Thank you, Mr. Representative.
Thank you, ladies and gentlemen.
The next item on the sign-up sheet is Jonathan Pasqua.
This draft is in the top B.
I failed to point out that he's a member of the Coventry Town Council.
Mr. Pasqua is a member of the Coventry Town Council. He was elected to that position in November of 2022. He's a career firefighter, and for the past 13 years, he's been employed full-time with the Coventry Fire District. Coventry Fire District is also known as Anthony Fire. The fire district is a quasi-municipal entity, is separate and apart from the municipal government. It operates under its own budget, and it's responsible for the collective bargaining agreement and the personnel management of that fire district. The Coventry Fire District, including Anthony Fire District, have faced significant challenges over the years. Some of you might be aware. Those challenges include threats of shutdowns, bankruptcies, and concerns over fire and EMS coverage across Coventry. Therefore, the petitioner represents that in November of 2022, the town council hired an outside company to assess the best path forward for providing EMS and fire services to the residents of Coventry. The company recommended that the town transition from fire district to a municipal fire department. In response to that recommendation, the town council created the Coventry Municipal Fire Commission. And the Fire Commission is tasked with studying the feasibility of any potential transition to a municipal fire department and with providing advisory recommendation relative to its finding. It is expected that the Municipal Fire Commission will present its recommendation by July of this year. Mr. Pasqua represents that it is expected that the town council will transition to municipal fire department. The creation of the municipal fire department only requires a vote on a resolution by the town council. However, Mr. Pasqua explains that an act of the General Assembly may be required for the abolishment of the fire district itself. Should the town move forward with the transition, it is expected that all union employees and firefighters will transition to that municipal fire department. Something similar was done with the East Greenwich Fire Department. Cognizant of the municipal official revolving door provision of the code, Mr. Pasqua is asking whether or not he may qualify for an exception to that revolving door provision in order to allow him to transition from his current position to a position with the municipal fire department. He represents that his employment with the fire as a firefighter is his livelihood, and without granting of a hardship exception that will allow him to make this transition, his family would suffer significant economic hardship. If the Ethics Commission opines that he does not qualify for a hardship exception, he would have to leave his town council, position before, July of 2025, so he can potentially be eligible to accept his position with the municipal fire department in 2026, which is expected to happen sometime in July. Mr. Pasqua is not a member of the Municipal Fire Commission. We've been in communication basis, and he's been recusing from town council's discussions that have to do with that transition. He is a member of the union, however, he is not on the executive board, and he's not going to participate in any bargaining agreement discussions and negotiations. He also represents that under the charter, he would be required, once he accepts, if offered the position as a municipal department firefighter, he would have to step down from his position of a town council. As everyone is aware, the municipal revolving door provision prohibits a municipal elected official while holding office and for a period of 1 year thereafter, seeking or accepting employment with any municipal agency in the municipality in which the official serves. However, that provision, regulation 1.5.4, has an exception to it. It allows the Ethics Commission to authorize an exception under circumstances in which doing so would not create an appearance of impropriety. The Ethics Commission had reviewed circumstances relative to that exception in several occasions. I have listed some past advisory opinions on pages 3 and 4. They're not really similar to each other. They're all different. I have also listed one prior advisory opinion on section 5.0, which is analogous to regulation 1.5.4 and has the same identical exception. That opinion factually was very somewhat similar to Mr. Pasqua's circumstances. In the instant matter, Mr. Pasqua has been employed as a firefighter for the past 13 years. This is his livelihood, and he hasn't participated in any of the discussion with regards to the transition from fire district to municipal fire department. Any transition is beyond anything that he has done. It's something that would have to happen. Based on the petitioner's representations, the applicable provisions of the Code of Ethics and review of the prior advisory opinions, it is the opinion of the staff that there is no appearance of impropriety under the circumstances, and therefore the staff recommends granting an exception to regulation 1.5.4. Accordingly, it is the opinion of the staff that Mr. Pasqua may seek and accept employment if offered as a firefighter with the town's anticipated new municipal fire department. And if and when the transition is completed, that will be without running the prohibitions. Thank you. I'm happy to answer any questions you may have.
Mr. Pasqua, you had an opportunity to review your opinion before you came today.
Yes, sir.
You had an opportunity to speak with Ms. Papa about it.
Yes, sir.
Do you have any additions or comments you wish to make about it?
I think the draft well represents the question at hand. This is a longstanding issue, and I'm just kind of in the mix of it. I'm not gonna be treated any different than anybody else. I'm just gonna fall under the blanket umbrella of whatever CBA comes out of it. Just looking to see if I can get relief on, to be able to continue serving as long as I can at the Coventry Town Council to address other matters that are important to the town that we're making progress on. But obviously step aside from this and just hoping to get an exception so I could eventually become a municipal firefighter like everybody else will be.
Your need to step aside is due to the town charter.
Yes, that's correct. There's
No dual employment under the charter.
correct. You can't be seated as a Coventry elected official and be employed by the town according to the charter.
Do any of the members of the commission have any questions or comments for Mr. or Ms. Pap?
Mr. Pasqua, how are you?
Good, thank you.
It's my understanding that the first time there was discussion in Coventry of the fire department's merging with the town was 50 years ago,
Yes,
right?
correct,
Okay.
correct.
Do you think you'll be using the exception any sooner?
I think the Municipal Fire Commission has a iron, strong focus on realizing what the feasibility is, fiscal impact, and the operational future would be of the town fire department. And I think the facts that they find, which are doing very good work, is gonna speak for itself. The council's very into, the sentiment is they're very into fixing this problem that you're correct, has been talked about for 50 years. Matter of fact, Fire Chief Frank Brown just retired the other day. And one of the stories he told was that when he came into the fire service 50 years ago, they told him, don't get comfortable, we're merging. It's been 50 years. It's been a hot topic for a long time, and it's a problem that's kind of on a runaway train, so hopefully it will be resolved by people other than me.
Good
So,
luck with that.
thank you.
Comments or questions from any other commissioners? I would just sort of echo, having had some dealings with those districts, that getting them gathered into one might be really good.
Yes, sir, I think it's on the way.
All right, any other questions, comments? Is there a motion to approve and issue the advisory opinion as presented by the staff? Motion by Commissioner Ritchie. Is there a second?
Second?
Second by Commissioner Peterson. Roll call vote, Commissioner Susie,
Hi,
Commissioner Stroud.
Aye.
Commissioner Browner.
Aye.
Commissioner Centarini.
Aye.
Commissioner Harrison.
hi.
Commissioner Peterson.
Aye.
Commissioner Rabidi.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. Thank you for coming in.
Thank you, ma'am.
That's good service.
Pleasure.
The next item on the sign-in sheet is William Perry.
Bring your firefighter to work day. This is at tab B. Welcome, Chief Perry.
Thank you.
The petitioner was appointed chief of the East Greenwich Fire Department on January 27th of this year. Because his brother is a firefighter in the same department, Chief Perry has submitted with his request for this advisory opinion an alternate chain of command policy for determination by the Ethics Commission regarding whether that policy is sufficient to insulate him from conflicts of interest involving his brother. Chief Perry was originally hired as a firefighter by the East Greenwich Fire Department in 2002. He was promoted to lieutenant in 2009 and eventually promoted to captain in 2018. This is not Chief Perry's first advisory opinion. He sought advice from the Ethics Commission in 2016 at the time of his brother's anticipated hiring as a probationary firefighter. Upon his recent appointment to chief, he and the town manager worked together to establish the latest proposed alternate supervisory chain of command policy. Turning to the relevant code provisions, in addition to the conflict of interest provisions identified, Regulation 1.1 spells out prohibitions against nepotism. By way of the big picture, as a public employee, Chief Perry may not participate in any matter as part of his public duties if there is reason to believe or expect that in this case his brother is a party to or participant or will be financially impacted or obtain an employment advantage by reason of the chief's participation. Additionally, and more specifically, Chief Perry may not participate in the supervision, evaluation, appointment, classification, promotion, transfer, or discipline of his brother. Nor may Chief Perry delegate any of those tasks to a subordinate. Looking at the alternate chain of command submitted by Chief Perry and the town manager, the policy specifies that the petitioner shall not make any discretionary work assignments to his brother, shall have no role in disciplining or evaluating his brother, shall not be involved in any promotional process concerning his brother, and shall not have any direct supervision of his brother. The policy further specifies that the petitioner shall not interfere with, discuss, or interview any fire department member involved in the supervisory responsibility of his brother for any reason, As stated in footnote 2 on page 2, presumably this particular directive is intended only to the extent that a particular matter actually involves the petitioner's brother. The policy includes a conclusive paragraph stating that the petitioner is not involved in any financial matters regarding his brother, as all of his brother's employment benefits are outlined in the collective bargaining agreement between the town and the firefighters union. Policy avers that it will remove the petitioner from any supervisory, disciplinary, or other responsibilities or involvement relative to his brother. Policy states the petitioner's brother will report directly to the particular lieutenant or captain during any given shift, just as he would in the normal, regular chain of command. However, the particular captain in charge will report any personnel matters involving the petitioner's brother directly to the town manager for review and a final decision rather than to the petitioner. There are a number of advisory opinions cited in the draft applying these provisions of the code to analogous questions involving family members. Like those situations in which a proposed alternate chain of command was found to be sufficient to insulate a petitioner from apparent conflicts of interest, the policy submitted by Chief Perry and the town manager is likewise sufficient in the opinion of staff. The policy does state that it shall not apply in emergency situations, including medical or fire-related calls. This is consistent with what the Ethics Commission noted in previous advisory opinions, including Advisory Opinion 2016-26, previously issued to this petitioner. During discrete emergency situations, such as fighting fires, where incident-specific supervision of his brother may be unavoidable, no nepotism violation of the Code of Ethics will exist. Chief Perry is encouraged to return to the Ethics Commission for incidents that might arise that were not contemplated or addressed in this particular advisory opinion. And by way of reminder to Chief Perry, any episodes of recusal must be exercised consistent with provisions of section 36-14-6. I'm happy to answer questions. I'll refer to Chief Perry.
Chief Perry, you had an opportunity to review the advisory opinion before you came today,
Yes, sir.
and you've had an opportunity to work with Mr. Regis to go through this as well.
I have, sir.
Do you have any additions, questions or comments on the advisory opinion that's presented to you?
No, sir, I have nothing more to add.
Members of the commission, anybody have any questions, concerns?
I,
Harrison?
I'm wondering how large the East Greenwich Fire Department is, because when you think about the handling of your brother and the chain of command in emergency situations, do you have coverage where this is actually realistic? I'm just speaking from my own little tiny fire department. I don't know.
So we currently have 36 firefighters. We have 9 firefighters on each platoon, which consists of 1 captain, 3 lieutenants and 5 firefighters. And the town's in process over the next month or 2 of hiring a deputy chief also.
Thank you.
Chief, you worked this out with the town manager and presented it that way, correct?
I have.
You're comfortable that you're going to be able to comply?
Yes, I.
Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Radadu, second Commissioner Peterson.
Harrison.
I'm sorry. I've told them before that I just can't stop this. Names, names. I was doing really well till now. All right. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner. Commissioner Centerini.
Aye.
Commissioner Harrison.
Aye.
Commissioner Peterson. Commissioner Radadu.
Aye.
Commissioner Ritchie. And I'd say my name wrong just for fun, but the chair votes aye as well. Thank you.
Thank you so much. Appreciate it. Thank you. Thank you.
The next item on the sign-up sheet, and I'll read it as it's presented, is Charlie Roberts. Mr. Roberts is a member of the Middletown Town Council.
This draft advisory opinion is on the tab G in your binders. With the risk of repeating it, Mr. Roberts is a Middletown Town Council member. He represents, there are several affordable housing projects that the town council is currently reviewing in the town. One of those affordable housing projects is located on Alton Lane, and I'll refer to it as an Alton project. That project is located across the street from Mr. Roberts' personal residence. His personal residence is within 200 feet with that proposed development, and he has received notices with regards to it. The Alton project is regularly reviewed together with another affordable housing project that is located or is proposed to be located at the former Berkeley Peckham School, or I'll refer to it as the Berkeley project. Berkeley project is not abutting Mr. Roberts' personal residence. Those two projects, Alton project and Berkeley project, were reviewed separately and voted on separately by the planning board. However, it is the representation of Mr. Roberts that for purposes of applying for funding to the Rhode Island House, the town presented an application with those two projects together. Rhode Island Housing denied that application due to the insufficient number of affordable housing units in those projects and because of the high price of the units. It is expected that the town council will be reviewing new proposed plans for those two projects and will be conducting public hearings which public will be heard. Mr. Roberts is asking, he's planning on recusing in his official capacity as town council member from discussions and decision making relative to those two projects. However, he's asking whether he may appear in his private capacity as a resident of the town, if he may appear before the town council and express his viewpoints on those projects. Here, as an abutter to the Alton project and with no rebuttal to the presumption that there will be a financial impact upon him, Mr. Roberts will be prohibited by the code from participating in town council discussions and decision making relative to those projects. However, the code contains a public forum exception under which he may appear before the town council during public comment and express his viewpoints on any matter that may have financial impact upon him, his family, his spouse or children, or a matter that is of general public concern. Here, it is the opinion of the staff that Mr. Roberts may appear in his private capacity before the town council during that public comment period and express his viewpoints with regards to those projects without violating the code of ethics. I'm happy to answer any questions. One more point, I'm sorry, I forgot. He may appear during public comment, however, he may not be afforded any other privileges that are not afforded to any other member of the public at that time. Now I'm happy to answer any questions you may have.
Mr. Roberts, you have an opportunity to review got your opinion before you came.
Yes, I have.
And you had an opportunity to talk to Ms. Papa on it.
Yes, I have.
Do you have any other questions or additions you'd like to make?
No, I do not.
First, the commission, anybody have any questions?
To council, please. The presumption of a financial impact that would cause the recusal is based on string of opinions. Am I correct?
Correct.
That's based upon that the person requesting the advisory opinion qualifies as an abutter to the proposed project.
Correct.
Now, one of the grounds, if someone were appealing a decision of the commission, that's controlled by the administrative procedure. Now, what is it controlled by?
State, APA only applies to state agency, this is municipal agency, right?
No, no, of the commission, this commission.
Advisory opinions or complaints?
No, in a appeal of this commission's decision to the courts.
Yes,
That's controlled by the Administrative Procedures Act.
I believe so.
Correct. Okay, one of the grounds for reversal is a error of law in the decision-making process. Okay, when you look at the legal definition of an abutter, which is within the enabling legislation for a municipality to adopt a zoning ordinance. That definition, I believe, is found in Rhode Island General Laws 45-24-31, subsection A, which defines an abutter, one whose property abuts, that is, adjoins at a border, boundary or point with no intervening land. There is a public street in opposite this gentleman's property between the proposal and his land. It would appear that he does not qualify as a legal abutter. Now, some may say that the notice provision in the zoning ordinance of you've got to give notice within 200 feet, that to me establishes a legal party of interest that's entitled to notice. But that notice provision does not create a abutter status in the gentleman. My question to legal counsel, if the presumption of a financial interest is based upon an abutter status, if the abutter status has been erroneously applied, what is the financial impact on the gentleman to require his recusal?
I think that the commission has the power to change the recommendation of the staff and go forward with different application of the law and analysis.
Mr. Strauss, did you want us to wait?
No.
I can answer some of these.
Okay.
The first part, which really isn't part of your question, but just mention it, is that, because it might be relevant, that advisory opinions are not appealed to the Superior Court of Administrative Procedures Act, because they don't have to follow your advice. They're free to disregard your advice, so there's no harm. But your point as to whether or not there's an error of law. So it is, it's possible that the definition in 4524, I'll take your word for it, that it doesn't apply to this situation where there's a public road in between the two things. As someone who helped the commission when they came up with this rebuttable presumption applied to abutters, the belief at the time was that the town's rules, or the town's ordinances, defined abutters as people within 200 feet of the subject property. And the discussion amongst the commission at the time that they first adopted this rebuttable presumption for abutters was that the fact that you're receiving an abutters notice, why are you receiving an abutters notice? Because there's a presumption that your property could be impacted by something that's happening on property so nearby. And I think the commission used abutter as, at the time they thought correctly. Hopefully it still is correct, but it's something we'll look into as to whether or not it's proper to call it. To say that the presumption applies to abutters versus the presumption applies to people who receive abutters notices under, but that's the intent, that it applies to people who receive abutters notices pursuant to municipal ordinance or or the enablement. Normally, they're the same, right? Sometimes they.
Another reservation that I have is an advisory opinion is issued in a significantly different procedure than the commission's rules and regulations. Public notice, promulgation, and whatever. The only other presumption that I am aware of within the code of ethics was statutorily created the presumption of innocence. I have a reservation that a presumption is created in an advisory opinion, not in conformity with the mandatory procedure regarding the adoption of a regulation.
I will say that I think your point is very valid as to the complaint process. So if we were prosecuting the petitioner for participating in the town council's decision-making relative to some abutting property, I would agree that we couldn't simply rely on this rebuttable presumption. Rather, we would have to produce evidence that he is being financially impacted by what's happening on neighboring property. The presumption is really only applied in the advisory opinion context to assist the commission in giving advisory advice.
But if I might, of course, I think that there's a more lengthy description of an abutter and notice in the Willis matter regarding administrative opinions. My counterbalance to that, in my thought process, is the gentleman is a town council. The gentleman, I don't know what, sir, do you run at large or do you run from a district?
It's
So you represent the whole community.
the entire community, yes.
Now, the people vote for the gentleman. I think the people, I'm trying to balance that the people should have an interest in the gentleman. The people have confidence in him being able to give his viewpoints. And that should be some sort of consideration that we just don't move ahead based upon certain factors to cause a recusal when the people thereupon denied their right of representation. Concern I have. Yes.
If I may, the last item I think is for code coverage. So I don't think that part is really subject to immediate discussion. I will comment because of my own knowledge. I don't want to get into a legal debate about it. There's no question that the term abutter has been used conventionally in zoning matters to 200-foot area. And it's based on a presumption of harm because the statute has a second provision, which says that a person has standing to bring a complaint in a zoning matter, pursue a zoning issue, if they can also prove actual. And so to their property. So the way I read that statute is that there's a presumption of harm to those who are within the 200 feet, harm or benefit within the 200 feet regulation, and need of proof outside that area. So I also would question, I don't know the law, whether the existence of a road constitutes an actual separation of two lots when it's the road often that people own to the middle of, and it's the road that is a public road that's 35 or 40 feet wide, and the only thing separate is the road. But again, I don't think for our purposes we need to answer those questions. I think you've raised very important concerns that I think Mr. Graham has heard. I'm going to do some thinking about. think we need to move forward with Mrs. Roberts' request. So I don't think you're suggesting anything that would require us not to pursue or respond to the request today. Is that correct?
Well, if there, and I'm not trying to deny it's right to secure a ruling from the commission, I'm not. But for the presumption, I don't see anything within staff reviewing that creates any counter evidence that he does have a financial interest, direct financial interest that would cause a substantial appearance of impropriety. I don't see it. But I'll confine that to my vote.
And I guess the earlier point is that it's an advisory. So you've raised some good points. He doesn't have to follow it. If he decides, maybe I'm not in the butter, he could pursue that. And then if a complaint was filed, as Director Gammon said, he'd have to show actual financial impact. So this is staff's opinion, and like you said, in your vote, you can find that, but he doesn't have to, it's not binding, it's an opinion, it's an advisory committee, right?
It's binding on us.
Sure, it is binding on us, yeah, and to that extent, I see what you're saying. But for his purposes, maybe he's gonna go looking to see if he's in a butter. We'll find out.
He's a remonstrant for years. Any further comment or question, Commissioner Ritchie? I didn't mean to cut you off.
Oh, sorry. Just, I'm sorry.
It's okay. I just didn't mean to cut you off. Is there a motion to approve and issue the advisory opinion as presented by staff?
So moved.
Motion by Commissioner Rabbit, is there a second? Second by Commissioner Susie. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Centerini.
nay.
Commissioner Harrison.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. The chair votes aye. Thank you, Mr. Roberts. We appreciate you coming in, your service.
Chair Jones, if I may, add something, we discussed with Mr. Roberts that there is a hearing by the town council on the 31st, and he would like to participate in it. But he is welcome to come back and seek for the guidance if he may participate as a town council member in those discussions. But for purposes of him participating in that meeting on the 31st and the restrictions of the commission meetings, the time we had allotted, I suggest that we move forward with the exception, and then if he would like, he can come back and seek the guidance.
Thank you. Thank you. The last advisory opinion is Tamba or Tamba.
Yes, that's at tab C. Mr. Tamba apologizes. He had a work commitment that prohibited him from attending today. He has asked that we proceed in his absence. Mr. Tamba accepted a position as an eligibility technician with the Rhode Island Department of Human Services on January 12th of this year. Prior to that, he had more than 25 years' experience as a professional accountant in the private sector. He owns and operates A&H Tax and Accounting Services, a small tax and accounting firm. Last September, petitioner, in his capacity as the owner of A&H, applied for a business grant under the Rhode Island Minority Business Accelerator Direct Grant Program, sponsored by Rhode Island Commerce. The original deadline for submitting a grant application was September 30th. He was supposed to learn last December whether he would be receiving a grant. The application period ended up getting extended. It was not until February 25th of this year that A&H received an email stating that it had been selected to receive a $10,000 grant. By this time, Mr. Tamba had become a state employee. He wants to be sure that acceptance of the grant will not violate the Code of Ethics. The petitioner is seeking an advisory opinion relating to an action that would not be taken in his official capacity as a state employee. The petitioner would like to accept the grant in his private capacity as the owner and operator of A&H. The grant, though offered through a state agency, is not offered through the state agency by which the petitioner is now employed. Also, there is nothing in the facts to suggest that DHS was affiliated in any way with that grant program sponsored by Rhode Island Commerce. For all of the foregoing reasons, the above cited provisions of the Code of Ethics, or the provisions cited in the draft, are not applicable here. Accordingly, it is the opinion of the Ethics Commission staff that the petitioner is not prohibited from accepting on behalf of A&H the grant award from Rhode Island Commerce for which he applied prior to his hiring as a state employee. I'm happy to answer any questions.
Do any commissioners have any questions for Mr. Bishop? Is there a motion to approve and issue the advisory opinion of staff?
I'll move.
Moved by Commissioner Peterson, second by Commissioner Harrison. A roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Harrison.
Aye.
Mr. Peterson.
Aye.
Mr. Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye.
Thank
Thank you, Mr. Deschanel. I believe that concludes our advisory opinion. And that means we go to the continuing discussion of the potential rulemaking, amending the Code of Ethics gift rule. Section 520 RICR 00-00-1.4.2. You apply to gifts from all registered lobbyists. Be presented by Director Graham.
Hello again. So this, today we do have a memo and a proposed amendment to Regulation 1.4.2 regarding gifts from Common Cause. It's in your packet behind tab G. It doesn't have its own specific tab. So if you're looking for it, behind a piece of blue paper, just past tab G. Common Cause submitted this last week. And just as a matter of transparency, I always want the commission to know that whenever we're dealing with proposed additions or amendments to the Code of Ethics, I always offer assistance to help review and format these proposals. I do it for the General Assembly, I'll do it for Common Cause, I'll do it for anyone. It doesn't mean I'm putting my stamp of approval on it. It just means I'm trying to get it in the best format possible for your review. I did that in this case, although the proposal is all Common Cause. So we have this on the agenda, as we will have on every continuing meeting, just to keep our eyes on it. But as I noted during the director's report, I have not been able to complete the staff's analysis and multi-state comparison. I intend to focus on that and hope to have it ready for hopefully the next meeting, if that's possible. So I'll leave it to you today. Mr. Marion from Common Cause is here, and he's here if you would like to hear from him or have any questions for him today. I advised him that it's also possible that you might just want to continue this matter to the next meeting until you have further information so that you don't duplicate your efforts. So I'll leave that up to you.
Does any commissioner have any questions or comments for Director Graham?
No, but, Judge, Commissioner Severini, we have the Rhode Island Trial Judges Association. We host all the legislature. And I'm reading where it says, as long as there's not an employed lobbyist. I don't remember if the judiciary had a lobbyist to advance or defend any causes that the judiciary has before the legislature. I thought there was one, I don't know if there's one now, but if there is one, I'm concerned whether or not it should now be prohibited. I just don't know.
You mean the event you're talking about? think that's probably a question for another time. After, there may not be a particular rule, so I think it's probably to come up if, as and when,
Well,
we get down the road a little bit.
you still, something tells me this.
The Rhode Island Supreme Court has hires a lobbyist. Whether none of the trial courts have input as to who that lobbyist is.
But we benefit. As a unified judiciary, for definitional purposes, means that any one of us can be assigned to any court except the Supreme Court. We would be subject to it. So I just raised.
Mr. Ritchie, I believe the answer to this question is, if, as and when, you'll be before us at that table, asking for an advisory opinion.
Well, yeah, true, very true. But again, but not only myself, but the judiciary, not necessarily have to come here, but I just raised that point for the language Mr. Marion proposed. So I don't know how to respond to that. But if you may.
Before we go to Mr. Marion, I'm happy to call him up. I think we should finish with Director Graham, at least if anybody has questions that we said so far. Mr. Marion, if you'd like to come forward and address Commissioner Ritchie's question. That's all right.
Okay.
Commissioner Ritchie?
Yeah, so thank you for letting me come forward and Marion. I just want to thank, Graham, it did format, help with that, which I'm grateful for. To the commissioner's question, there's three parts to this. So I just kind of want to recenter us because I know I had three proposals before you. We're down to a single proposal, which deals with what I would characterize as a loophole that exists for lobbyists who represent not-for-profits. And what I proposed has three parts. The first part would put not-for-profit, all lobbyists and those who employ lobbyists under the definition of an interested person. The second part, would make explicit that it applies only to those that they are lobbying, because that came up the commission. And then the third part, which is explained in the fourth or fifth paragraph, starting in the fifth paragraph of my letter, deals with what I think is what you're describing, which is I went through advisory opinions going back decades and tried to identify when lobbyists or those who employ lobbyists were told by the commission what you're doing is okay, even though you employ lobbyists or are a lobbyist. And what I found was that the single instance where lobbyists or those who employ lobbyists were sort of given the okay to give gifts to public officials they are lobbying is dinners. So the most notable one being the Rhode Island Public Expenditures Council, which has an annual meeting, convention center, where they invite the whole General Assembly and provide them dinner. And I found actually that there are exceptions, I think I say, in 23 states for sort of food and beverages being provided by lobbyists if they're consumed in the moment, but they're offered to everybody in the legislature at the same time. And so part of the rule we propose on page 4, starting in subsection D, 3, and then in the 4, with food or beverage for immediate consumption at a reception or fundraiser, to which all members of the General Assembly or statewide officers are invited. It's hosted not more than once in any year by a not-for-profit entity. that is not an interested person as defined in subsection C1. Now that obviously applies to not-for-profits. I think you've raised an issue, which is government does employ lobbyists as well. And I hadn't thought of that or tried to address that in here, but I think as this, we choose for this to move forward, we should consider that.
Any other questions, Ms. Mary?
We just limited to this, or can we ask other questions?
The floor is open, Commissioner.
Okay.
Commissioner, understand that it's, to me at least, unlikely that we would actually address this.
Am I correct? In evaluating where we are at this time, that there has been a movement from your organization to request the inclusion as a category lobbyists, and that's been refined as of this point to those within the purview of the amendments you're suggesting. And if I'm not being clear, I thought initially your request was classification, whether they qualified as an interested person regarding the governmental official.
Yes, and sorry if I wasn't clear. So the original goal was, and what we requested of the commission was to include lobbyists as a class in the definition of an interested person, whether there was a financial impact on them or not.
And at this time, your organization has moved from that request to recognize the limitation of financial interest.
Understand?
No?
I don't think so.
Yeah.
That's what the proposal is, yeah.
So the proposal, I think, would do that. It would add to the definition of an interested person, lobbyists and those who employ lobbyists, regardless of if they have a financial are financially impacted. But then it refines that to narrow it somewhat based on the feedback I received from the commission so it applies to those they are lobbying or paying a lobbyist to lobby. And then it further refines it to deal with this issue of meals where the whole General Assembly is invited.
Utilizing the example I inquired of the last time, lobbyist. Addressing the snow plowing contract for Block Island. But the lobbyist has no matter of financial interest to a person he invites to the basketball game, URI basketball game.
And you're saying that person is unconnected to the issue?
Unconnected, just on Block Island.
That's what's being taken out. The potential lobbyist would end up taking a gift from you, for example. You hire him, but he's not lobbying on the issue that is concerning to you. You can go off and do anything you want. You give a gift to someone who's not lobbying your issues. That's the way you drafted it, correct?
Yes, so
it is taking out as a classification of a lobbyist. It is.
but it's not. It's not trying to redefine lobbyists, saying if you are a lobbyist, the gift rule applies to you, except if you are trying to give a gift to somebody who is, you aren't lobbying, unless the interested person analysis still applies. So under your Block Island example, I think what we proposed would allow the gift as long as the interested person analysis didn't apply.
Can I give an example? Then I'm just make sure I'm on the right path here. So somebody's a lobbyist at the state house or state government. and they register, they have to click off what groups, whether it's all officers or just general assembly or whatever. So if all the general officers were not included, then they're not a lobbyist to them. And so that wouldn't apply. So that's an exception. I have that right?
Yep, because they aren't.
As long as not interested.
Right.
Yeah.
Lobbyists for common cause, there's no financial interest, but if they are lobbying someone for something, then it would apply. So it's covering that, it's covering lobbyists with their financial interest. Yeah.
Maybe
Making them
maybe I
interested.
misconstrued the original proposal to require, if you were a registered lobbyist on the Block Island snow plowing contract, and you invited somebody to the URI basketball game, what I perceived their interest to be originally, that met the code of ethics, in violation of the code.
That's how it was drafted.
That's how it's written.
That was
But
the
so,
original
okay,
idea, and then based on the two meetings where I appeared, I heard your example and tried to draft
Yeah.
otherwise.
Any other questions or comments to Mr. Marion?
Beyond the example that you cited concerning, the expenditure council, it's my understanding, like, various, departments, business bureau, whatever it is, they invite all members of the General Assembly to their annual dinner, and it's I would imagine some of the regional ones do so too. If they invite all, under your last proposal, on page 3, that would be allowed if it's for food and drink.
Consumed at that point, yes.
Does that proposal specifically it takes out from the code the $25 limitation and the $75 limitation. So you could give them, you could give them a 3-pound lobster that may be over 20.
Yeah.
The general assembly.
But what's interesting, I think, is that immediate consumption, which is language that appears in many states, because the idea is they couldn't walk away with a bunch of lobsters under their arms to take home to their family.
Yeah, but can they walk away with it left?
Oh, gee.
That's good. Another clarification, please. Where you address in that same provision, General Assembly or statewide law, was there a specific reason why confidential employees or senior staff aren't included? Because when you look at the code, you can see like for appointment purposes, one position to the other, there's a recognition that senior staff members or senior policy people, sometimes accompany the office holder, because the office holder may be relying on specific expertise of staff. Why wasn't that exception recognized on paragraph, on number 4 of 5? Was it oversight or not considered?
Yeah, it wasn't, I hadn't considered that.
Food for thought.
Well done.
Does anybody else have any comment or question of Mr. Marion? Thank you. Anybody have any further questions, Mr. Graham, in light of our conversation with Mr. Marion? I want to confirm with Director Graham. I think what you were saying to us is that You've received information from Mr. Marion about the study of other states, but you've not had sufficient time to review that. And one of my concerns is whether they're actually parallel situations, and I want to know about whether these are actually gift rules that are directly in a statute involving lobbyists versus some sort of ethics. So I'm going to ask if there is a motion to continue discussion of this proposed rule and the rulemaking process until our next meeting. Motion by Commissioner Ritchie, second. Second by Commissioner Browner. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss. Aye. Commissioner Browner. Aye. Commissioner Centarini.
Aye.
Commissioner Harrison.
Aye.
Mr. Peterson.
Aye.
Mr. Rabideau.
Aye.
Mr. Ritchie.
Aye.
And the chair votes aye. Thank you both. All right, at this point, is there a motion to go into executive session to wit, a motion to approve the minutes of the executive session held on March 4, 2025 pursuant to RI Gen 1, section 46-5, A 2 and 4, and In re Jason E. Licciardi, complaint number 2025, I'm sorry, Mr. Jason E. Licciardi Senior, complaint number 2025-1 pursuant to our general section 42-46-5, A 2 and 4. Is there a motion? Motion by Commissioner Susan.
Could I just get a clarification? Perhaps I wasn't listening, while I was thinking about something. But does that motion address the approval of last month's executive session? Need to recuse
It
yourself.
will when we get.
Thank you. Thanks.
So what we have before the commission is a motion made by Commissioner Susie, seconded by Commissioner Browner. I believe that's correct. To go into executive session, a roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss. Aye. Commissioner Browner. Aye. Commissioner Centarini.
Aye.
Commissioner Harrison.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. The chair votes aye. We're now going to executive session. Commissioner Ritchie, before you stretch, because I think we'll wait till we reach the item that is of concern to you. Someone else, Rabideau. All right.